Okay, good evening. I'm recording the class. Recording will, as usual, be uploaded on YouTube. I still have to upload Monday's recording. I will do that this evening. So yes, we're busy looking at lease agreements. We're done with contract of purchase and sale, moved on to lease agreements. Always remember that we are dealing with contracts, so the general principles of the law of contract, those first couple of units that we did, apply throughout. Never forget about them. Let me share my screen. Just give me a thumbs up if you can see the page that I shared. Thank you, Benjamin. Okay, so looking at lease agreements. Sorry, please do bear with me. I've got a bit of a bad cough. So in order to know what the natural legal consequences of a lease agreement is, we need to firstly be able to identify whether a specific contract is a lease agreement or not. Requirements for a lease agreement: obviously it must be a valid contract. This contract must then must contain a reference to the property, because a lease is for the use and enjoyment of a property. It must specify that the use and enjoyment is temporary, and it must refer to the rental. So moving on then to look at the rights and duties of the respective parties to a contract of lease. These rights and duties are natural legal consequences. They apply because it is a lease agreement. They can, however, be changed or excluded, but then it must be done expressly between the parties. So let's look then firstly at the duties of the lessor. The lessor, you're welcome to also use the word landlord. If it's a fixed property, you will use landlord as opposed to lessor, though lessor is also correct. That is the owner, the person who rents out the property. So the first duty of the lessor is the duty to deliver. Delivery in this context has a similar meaning to what it has in the law of purchase and sale. Delivery means that the property must be made available. It must be made available to the lessee in such a position, such a state that the lessee must be able to take free and undisturbed possession of the property, possession of the property. So if you are renting a house at the date when your lease starts, it should be available for you. If there are still other people staying there, then that is a problem, and the landlord, the lessor, will be in breach of contract. What condition must it be when it's made available? It must be in a proper state of repair. Property must be in a proper state of repair and reasonably fit for the purpose for which it is rent. So if you are renting a property as a place to stay in, a residential property, it must be in a condition that people can reasonably live in it. Date of delivery will be as determined, obviously, in the contract. Apart from delivery in a fit state, the lessor is also responsible for maintenance of the property. The thing must be maintained. So the must be maintained in a proper state of repair. So it is delivered in a fit state, and the landlord is responsible to, if the roof is leaking, to fix the roof, the geyser breaks, fix the geyser, etc., etc., etc. Now, just remember here that before you now all get excited or angry and end up running to your respective landlords tonight and starting to fight and tell them, but Ms. Hanekom says, Ms. Hanekom also said, the beginning of the class, these duties are natural legal consequences and they can be changed. So before you start shouting at your landlord or whoever about them not doing what they're supposed to do, make sure you read your actual lease agreement. Make sure you read your actual lease agreement to see what it states in your particular instance. Because this is one of the consequences of a lease agreement, which is very often varied in a particular agreement. In addition to maintenance, the lessor must grant the lessee undisturbed use and enjoyment of the property. Once the property has been delivered, they need to stand back and allow the lessee to use it in the way that they deem fit. The lessor undertakes that he or she will not do anything which unlawfully interferes with the lessee's use of enjoyment. And similar to purchase and sale, that no person with a superior title will evict the lessee. So at no stage, don't know if you noticed this, at no stage did we say that the lessee must be the owner of the property let. Similar to the law of purchase and sale, the lessee does not have to be the owner. However, they must guarantee that the lessor will have undisturbed use and enjoyment. So somebody with a stronger title will not come and kick them out. This undisturbed use and enjoyment, however, is qualified by the previous duty, because the lessor must maintain the property. And obviously, in order to maintain the property, to perform maintenance, fix things, they will need to, on occasion, enter the property. So the lessor has the right to enter the property for maintenance. This must obviously at all times be done in a reasonable manner. They cannot just pitch up there at any time. They have to give notice that they will be coming, etc., etc. If it is necessary, for the needs of maintenance, the lessee actually also even has the right to request the lessor to vacate the property, to move out for a certain period of time, if it is necessary for the sake of performing maintenance. If it is a fixed property and there are property taxes payable, this is also the statutory duty of the lessor to pay the taxes. This is also a duty which can be changed in a particular lease agreement. Always read your lease agreements. Any questions? Fairly straightforward, actually. This unit on lease agreements is actually very much self-explanatory. I didn't actually even have to teach you. I could just have told you, just study that unit. It speaks for itself. Benjamin?
Yes, evening, ma'am.
Yes, good evening.
How are you, madam?
I'm very good, and yourself?
I'm good as well. Now, I would just like to know who is responsible for paying taxes and rates. Is it the lessor or the lessee, or both?
That depends, as I've just said, on the specific
Oh,
provisions
so
of your specific lease agreement.
oh,
It
oh,
is
it
one of
needs to
the,
be
yeah,
also specified in
yes.
the agreement, in the
If it is
contract,
not,
actually.
yeah, Benjamin, if it is not specified, if the lease agreement is silent about that, it is the lessor, the landlord's duty to pay the rates and taxes.
Okay.
Rates and taxes, I'm not saying electricity, I'm not referring to utilities, the electricity you use, the water you use. I'm talking about property tax, the rates that you pay to the municipality.
Yeah.
It is one of the duties of the lessor to pay. But that is one thing, because these duties, as I have explained previously, can be changed in a lease
Okay.
agreement between the parties. So
Okay, ma'am.
it could be that you have a lease agreement which says that as the lessee, you have to pay them. And then, of
Oh,
course, in terms of the contract, you've agreed to pay them, so you have to pay them. But if your lease agreement is
yeah.
silent about that, the
Mhm.
natural legal consequence will follow. Other words, the landlord, the lessor, has to pay.
Okay, madam.
Are you with me?
Mm. Yes, ma'am. Thank you,
Okay.
ma'am.
Pleasure. People, please just keep unless you're communicating with me directly, keep your mics muted so that we don't have background noise. Okay, any further questions about the duties of the lessor before I carry on?
You may continue, ma'am.
Okay. So then those are the duties, quite straightforward. Duties of the lessor. Duties of the lessee, also very straightforward. Obviously, the very first one, the most basic duty. Who's going to try to guess what the most basic duty of a lessee is? Take a quick guess. The most basic duty, the most obvious thing that you have to do if you're renting something. Yes, Mitchell. Mitchell, Apollonia, shout out, either one of you. You've both raised your hands.
It'll be, I think, paying the rent on time.
Yes, as simple as that. You don't need to be a law graduate to know that. Absolutely straightforward. They need to pay the rent as and when agreed in terms of the contract. Interestingly, this is something that you might find strange, that you might not be aware of. The default rule is that rent is payable in arrears. So at the end of the month for the previous month. So only at the end of January for the month of January, at the end of April for the month of April. That is the default rule. But once again, don't go running to your landlord and tell him, Ms. Hanekom says, Ms. Hanekom says. Because, as I've said before, these natural legal consequences can be changed. And it is pretty much standard practice that the contract will provide that the rent is paid in advance, that you have to pay in the beginning of April for the month of April, not only at the end of the month. But if there's no specific reference, once again, then the default rule will apply. It is payable in arrears. Although the landlord has the duty to maintain the property in a proper state of repair, this doesn't mean you can go ahead and do exactly what you want to. The lessee has the duty of proper use and care. Firstly, property can only be used for the purpose for which it was let. So if you rent a room in a house or maybe the whole property for the purpose of a residential property, you may not legally, without the permission of the landlord, use that property to run a business. It was let as a residential property, you can only use it to live in. If any damage is caused By the improper use of the lessee, it is the lessee's responsibility. To fix this. So the landlord has the duty to maintain the property, duty of maintenance, but for damage specifically caused by, so not damage as a result of normal usage, normal wear and tear, damage caused specifically by the lessee is their responsibility to repair. And then at the end of the lease, the duty to return the property in the condition that it was, normal wear and tear excluded. So obviously, if you have been staying in a place for a year, there is going to be some damage that is going to result, normal wear and tear that results if people are staying in a place. But damage caused by you, if you hammered nails into the walls in order to hang up your paintings, you have to remove them and fix the walls, make sure the place is properly clean, etc., etc., etc. So those are the duties of the respective parties. Pretty straightforward, common sense. Any questions about that? No questions?
You may proceed, ma'am.
Let's look at renewal of a lease. A lease is for a temporary period of time. It is never permanent. But if a lease was for a specific period of time, and that time period has expired, in most instances, depending once again on your specific lease agreement, you will be able to renew it should you so wish. Now, a lease can be renewed in one of two manners. Some terminology. A conventional relocation. Must remember these terms. Going to assess you on them. Oh dear, spelling, relocation. Why can't I spell now? So sorry about that. Conventional relocation. That is when the lease agreement is renewed expressly. So your lease agreement has expired or is close to the expiry date, and you request the landlord, the lessor, if you can renew the lease and continue staying there for another year. Most lease agreements make provision for this and how it must be done, how much notice must be given in advance, etc., etc. If it is renewed expressly, it can be at new terms. You can renegotiate, for example, an increase in rental. This is what happens in most instances, that if you renew your lease, then the rental will increase by a certain amount or a certain percentage. But something you might not be aware of is that it's also possible that a lease agreement can be renewed tacitly, quietly, known as a tacit relocation. This is an implied agreement. What happens is that the lessee remains in occupation continues to pay the rent, and the rent by the lessor. So when the year is over, instead of moving out, you simply stay there. You don't move out, you just stay there, and you continue paying the same amount as you used to pay. And the landlord accepts your new payment. So if your lease agreement expired at the end of December, but in January you stay there and you pay the rent for January, and the lessor accepts this. This is an implied renewal of the lease agreement, known as a tacit relocation. And the interesting thing about this is the lease agreement renews on the same terms. So if he accepted your same rent for January, he cannot quickly suddenly come in February or March and say, oh no, but now you must pay more, because your lease agreement renewed on the same terms, only difference being, whereas where you previously might have had a lease agreement for a fixed term, the lease agreement can now be terminated by notice. He can give you reasonable notice. Also can't come and kick you out and say, no, you've got to leave by the end of the week. But he can give you reasonable notice to terminate the agreement. So instead of a fixed term contract for a year, it now becomes a lease agreement terminable by notice on the same conditions, the same terms. Everybody with me?
Yes, ma'am.
Now, what would happen if the lessor sells the property? Does that mean that, okay, sorry, now you have to find another place to stay? No, it doesn't. This is an interesting legal concept which applies only to lease agreements. It is quite unique to lease agreements. The concept of hire goes before sale. Sorry. Also sometimes known by the Dutch. This is not Afrikaans, this is Dutch. Remember, the origins of our law is Roman Dutch law. The concept of huur gaat voor koop. Hire goes before sale. Unique to lease agreements, which applies only to immovable property. So this applies only to immovable property. It does not apply to movables. So if Benjamin had a lease agreement with me to lease my cell phone, and while he's in possession of the cell phone, using it, paying rent, I sell the cell phone to Apollonia. My lease agreement with Benjamin will come to an end. It will be terminated. He needs to return the cell phone so that I can deliver it to Apollonia. That makes sense. But for immovable property, the concept of huur gaat voor koop, hire goes before sale, provides protection. It protects the lessor in instances where the immovable property is sold. What it means is that the lease agreement will continue. Does, however, not apply in all instances. When does this hire goes before sale apply? In the instances where it is a short lease. A short lease is anything less than 10 years. Hire goes before sale will apply to a short lease if the lessor is actually in occupation of the property at the time of the sale. So is actually living in the property. If they have a lease agreement, but they aren't there at the time, they will not be protected. But if they are physically living at the time, then they will be protected. If the successor in title the successor in title, that is the person, the new owner. The new owner is aware of the lease agreement. By the way, these requirements, these instances, they are all agreements. So if the lessor is in occupation, or the lessor in title, even if they weren't in occupation, but the new owner, the successor in title, is aware of the lease agreement, or if the successor in title obtained their title gratuitously free of charge. Other words, without paying for it, other words, if they inherited the property, for example. If they paid for it, they didn't get it for free, they paid for it, then the lessee will only, the lessee will only be, sorry, this is lessee. If the lessee is in occupation at the time, or the lessor, the new owner, is aware of the lease agreement, or the successor of title obtained the title gratuitously without paying for it. In these instances, the lessee will be protected until the end of their lease agreement. For a long lease, a long lease is more than 10 years. Now, what you need to know about a long lease is that it can be registered in the deeds registry. So when you enter into a long lease agreement, long lease is normally for a rural lease, a farm, then you can have it registered in the deeds registry, and an annotation is then made, a note is made against the title deed of the particular property. So it can be registered. But I'm emphasizing that it can be registered, not it must be registered. If it is not registered, it is still valid. Students often make this mistake and they tell me, no, it wasn't registered, so it's not valid. A lease for 50 years is still valid, even if it's not registered. But whether it's registered or not has an impact on the operation of the huurgehad-voorkoop rule. If it is registered, the lessee can occupy for the duration of the lease. So if Mitchell rented a farm for 20 years and that lease agreement was registered in the deeds registry, and after she's only been there for a year, the owner of the property, the lessor, sells the property. If it was registered, she can remain in occupation. She can continue with her lease agreement for the remainder of the lease. So she can continue then, if it was only a year that's passed and it was a 20-year lease agreement, she can literally continue for a further 19 years. And this applies whether or not whether or not the lessee is in occupation of the property. So even if she isn't actively living there or using it to farm, as long as she's paying her rent, the new owner, the successor in title, remains bound to the lease agreement. If it is not registered, and the new buyer was not informed, the lease agreement for a period of 10 years Please note, this is the first 10 years of the agreement. So if Mitchell has a lease agreement that for 20 years and it was not registered, and 9 years after they entered into the lease, after 9 years has expired, 9 years has passed, and then the lessor sells the property, she can continue for another year. So the lease agreement can continue for a period of 10 years, not from the date of sale, but from the date of the first date, the date that the lease agreement was entered into. Provided the lessee is in occupation of the property. After the 10 years has expired, the lease agreement will terminate and the lessee can be evicted, provided they are in occupation of the property. If the new owner knows whether it was registered or not, if the new knew about the lease, the lessee can remain in occupation for the full duration of the lease. So whether or not it's registered, whether or not the lessee is in occupation, if the new owner is informed, the lease can continue for the full duration, however long it is. And then similar to this one, if the successor in title obtained the title gratuitously without paying, the lease will also continue, whether he knew about it or not. For the full duration of the lease. So that might seem a little bit complicated. Isn't really, if you look at it carefully. Those are the instances there when the huurgaat verkoop hire goes before sale rule will apply, and the lessee will be protected and can remain in occupation. The lease agreement will continue. Any questions about that? No questions? Okay, then the last bit of this unit is just about termination of a lease agreement. Really nothing here that I have to teach you. A lease agreement can either terminate by way of notice, either as set out in the lease agreement or by way of reasonable notice, or otherwise, if it was a fixed term contract, by way of effluxion of time. So if it was for a year, once the year is over, the lease agreement will terminate unless it is renewed. There, that's all I need to teach you about lease agreements. Nothing complicated at all. Also something that you can all identify with, because I'm pretty sure the majority of you have at some stage or are even still currently entered into a lease agreement. Any questions? No questions. Okay, so we're done with lease agreements. That was a fairly short class. Thank you for having joined. It's still nice and early. Have a wonderful evening for the rest of the evening.
Thank you, ma'am. Have a wonderful evening.